Okay. Um, right. Welcome. First of all, just some administrative matters before I start the class. Uh, I shared assignment 2 with you last night. Then I revised the instructions slightly, not drastically. Shared a revised version this morning. It's also on e-learning. Now, with assignment 2, I'm trying something different. And I really hope it's going to work because at the end of the day, I actually just want my students to learn something and be able to pass. Now, I've realized that it's a losing battle. We all know AI, artificial intelligence, is here to stay. It is a losing battle fighting against it. Doesn't matter how much I say to you, do your own work, don't use AI. You're going to think you're smarter than I am and that I won't pick it up and use it in any event. So in assignment 2, I have given you a short case study. And part 1 of the assignment is literally instructing you to use AI to answer this case study. But AI gives you American law. It doesn't give you Namibian law. Even if you specify use Namibian law, it still gives you American law because it doesn't know the difference. But there are um, quite important differences, specifically terminology-wise. Um, so part 1 of the assignment, I'm literally telling you, use AI to answer this question. And then part 2 is you have to take the AI-generated answer and rewrite it, because that is how you properly use AI. AI is not mindless copy and paste. AI can help you a lot. It can help make your life a lot easier. Got nothing against that. But you need to use it intelligently. So you need to use AI to generate an answer. And I want to see your AI generated answer. And then you have to rewrite it and recheck it based on the material available in your study guide. Make sure that the references, the terminology, the application, etc., is correct, corresponds with your study guide. And you do that on the same document. So first you open a Word document, you paste your AI generated answer, and then same document, separate page, you do part 2 where you have redone it. And hopefully, not only will you learn something about the law in the process, but you will also learn something about the proper application, how to properly and intelligently use AI. Having said that, that applies for assignment 2. Assignment 1. Assignment 1. If you use AI to answer that assignment, the instructions for that assignment says very clearly, use only the study guide. Don't Google, don't AI, don't anything. Use the study guide and answer the questions yourself. That is how you learn. You do not learn by getting AI to answer this for you and copying and pasting an AI-generated answer. I'm going to ask you these same questions in the exam. If you worked out the answer for the assignment, you get the question in the exam, you can answer it. If you copied and pasted something that AI gave you into your assignment, you might, well, you won't get good marks, but in any event, you might think you're going to be getting good marks. Then you get the same question in the exam, and you've literally never actually seen this answer because you didn't read it, you copied and pasted, thinking, ha ha ha, I've Miss Hanekom. I'm going to get such good marks for my assignment. When I grade assignments that are submitted via Turnitin, when you submit, it gives you the similarity. Similarities these days have actually become irrelevant because students no longer copy from each other. They don't copy and paste from the internet. They use AI and then they copy and paste. So similarities look relatively under control, not too high. If I grade an assignment on AI, on Turnitin Moodle, it actually gives me an AI score as well. Tells me how much of this submission was AI generated. You didn't know that, did you? I don't actually even know that because I've worked with AI generated answers enough for the past 3 years or so since it became a thing. I recognize the way AI writes. It has a style. I recognize that. And it uses American law. It uses terminology which is not in the study guide. There was one submission that one student that submitted early. Thank you for making the effort to submitting early. You've saved yourself by submitting early, because I had a look at your submission just before I started setting up for the class. Your assignment is AI generated. You are going to fail. You will get less than 10% for that assignment. What I do if I see AI generated answers, I write and make a comment saying, not your own work. And I give you a 0 without hesitation. You have time to go and do your own work and resubmit. Take me seriously or you will get 0 for your assignment. Having said that, you're doing your first quiz on Friday evening. It's quick, 40 marks, 45 minutes. It's not overly complicated. I figured out when the commercial students did their test last week and Friday, that students have now thought they can actually cheat the system by using AI to answer a multiple choice quiz. I can't stop you. If you think you want to cheat yourself into a degree, then I can't stop you. Just remember, you need to write a face-to-face exam. And it doesn't matter how high your semester mark is because you cheated yourself into a high semester mark. You write a face-to-face closed book exam, and you need a minimum of 40% in the exam to pass. So even if you go into the exam with an 80% semester mark, if you cannot get at least 40% in the exam, even if your final mark is above 50, you will still be failing. Do not think you are smarter than I am. Okay, that's my speech for the day. We have one more unit to do. which is also included in the quiz. Thumbs up quickly. If you can see the screen, I've shared my screen. Just give me a thumbs up if you can see it. Thank you, Mr. Sharuma. Okay, so terms of a contract. What do I mean by terms of a contract? Terms of a contract, that is the contents of the contract, the words. We've looked at what are the requirements for a contract to be valid. We've looked at breach of contract, what happens if something goes wrong. Then we looked at how do contracts come to an end, termination of contracts. Now we're looking at, you've got a valid contract, having a quick look at content, the words. So terms can be classified into 4 different categories. Firstly, express terms. Express terms, these are literally the words, whether orally or in writing. Remember, we've learned that contracts do not have to be in writing to be valid. Your express terms, they're the backbones of this contract. The words spoken, either spoken or written. Then, in addition to express terms, the law also recognizes tacit terms. A tacit term is not expressed in words, but is read into the contract because it's essential to reflect the true intention of the parties. Let's just use an example here. Mr. Sharuma agrees with Nust that he will play rugby for the Nust Rugby Club, and they will pay him a certain amount of money. Contract says $5,000 a month, play for Nust Rugby. Fine. Then the first practice training session Nust Rugby has, Mr. Sharuma doesn't pitch up for practice. So the coach contacts him and says, but Sharuma, where are you? Why didn't you come to practice? And he says, oh no, my thing about attending practices, attending training sessions. It says I must play with you. I'll be there on Saturday. Does that make sense? Agree with me quickly? Would that make sense? That he needs to play, so he'll come on Saturday, but he's not going to train with the team?
No, it doesn't make sense.
Of course not. So although the contract doesn't expressly say attend training sessions on whatever days of the week, so many times a week, it would be a tacit term of the contract. In order for proper fulfillment of the contract, there would be a tacit term, a term that is read into the contract, not expressed in words, but essential for the proper fulfillment. In order to play for them, you must also wear their kit, join in training sessions, etc., etc. Word of warning, courts do prefer not to read things into contracts unless it is absolutely essential. Then you get implied terms. confuse tacit terms with implied terms. Implied terms, these are natural legal consequences which flow from a specific type of contract, unless it is expressly excluded. If, for example, trying to keep it to sports law, keep it relevant to what you're studying, an agency contract. If a sportsman appoints an agent, it will be an implied term. Implied terms often relate to the duties of the parties. And an implied term would be if you are acting as an agent for somebody, you must act in the player's best interest and avoid a conflict of interest. The contract of appointment, the agency contract, doesn't have to specifically state that the agent must act in the player's best interest. It is read into it. It is an implied term. It is part of it. Implied terms then particulars to a certain type of contract. So there are certain implied terms that apply to agency, certain that apply to labor, certain that apply to purchase and sale, etc., depending on the nature, the type of contract. They will always apply unless the parties have expressly decided to exclude them. So when Sharuma appoints Mr. Hayala as agent, they can, in their contract, agree that Mr. Hayala does not have to avoid a conflict of interest. They can legally do that because it remains an agreement. Obviously, you can figure out for yourself that would just be dumb. Why would you not? Why would you release your agent from acting in your best interests? But you can legally. And then you get incidental terms. Incidental terms, these are your extras. They are not essential to the validity and the performance of the contract. They just add extra details. So in the rest of the unit, we look at some incidental terms. You need to know them. You need to be able to identify them. Now, something you might have seen, you see this quite often. It annoys the living daylights out of me. In advertisements, magazines, on the radio, on TV, whatever, somebody's advertising something, and then there'll be a sort of a disclaimer saying, T's and C's apply. Have you ever seen that? Give me a quick thumbs up if you've come across this ridiculous phrase saying, T's and C's apply. Please never, thank you, Mr. Sharuma, please never use that in front of me because I will run away screaming. T's and C's apply is dumb and stupid. It's supposedly short for terms and conditions apply. But a condition is merely a type of contractual term. So saying terms and conditions apply just shows that you don't actually know the meaning of what is a condition. So what are conditions? A condition is a contractual term that renders the operation of a contract depend on the occurrence, the happening or non-happening of an uncertain future event. So it relates to something going to take place or not take place in the future. But we don't know for certain whether this is going to happen or not. An example there, I agree with Marlies, she can borrow my umbrella if it rains in Windhoek tomorrow. We do not know for certain whether it is going to rain in Windhoek tomorrow. Now, conditions can be, you can get two types of conditions. You get suspensive conditions and resolutive conditions. You need to know the difference between these two. What is a suspensive condition? What is a resolutive condition? Suspensive condition. To suspend, to keep something hanging, literally has a similar meaning. So there is a contract. We have a valid contract. Remember, always we're talking about valid contracts now. We have a valid contract, but the obligations don't start yet. So the contract is valid, it has been entered into, but the obligations are suspended and will only start happening if this uncertain future event takes place. Resolutive, to resolve, to dissolve, similar meaning. There's a contract, the obligations have started, but if the uncertain future event happens, they will stop. So an agreement with somebody that she can stay in my house until she fails a course at NUST. So she moves in the meantime, and she can stay there. It's a condition, it's an uncertain future event. We don't know whether she's going to fail or not. We're hoping she isn't. But if this uncertain event happens, the obligations come to an end, she must move out. So that is a condition. Renders the operation and consequences dependent on an uncertain future event. So condition isn't a separate thing on its own. It is a type of contractual term. Stupid to say T's and C's apply. A time clause is similar to a condition, except that it refers to something that will definitely happen. So a future event, we are sure it is going to happen. We just don't know exactly when. Time clauses can also be suspensive and resolutive. Suspensive and resolutive have similar meaning as they do when you're referring to conditions. So suspensive, there is a contract, but the obligations are suspended. They will only commence when the future event takes place. So I agree that she can borrow my umbrella when it rains again in Windhoek. We are sure it is going to rain again in Windhoek. Okay, at the moment it's raining non-stop. But even in periods of drought, we know that at some stage it will rain again. Time clause, certain event. Resolutive, obligations have started, but will come to an end. She can stay in my house until the end of the year. So obligations start, certain future event happens, it becomes the end of the year, obligations end. Any questions about that? Okay. Potential test question. Each of the following instances indicate whether it's subject to a condition or time clause, whether it is suspensive or resolutive. And then I've also already told you to identify the contractual term. Seeing that this is a level 7, a level 6 course, my depth of assessment goes a little bit further than to what I expect from my accounting students. So I can also ask you to give an example. So you need to be able to do it both ways around. Okay, so let's look at some further contractual terms. These are fairly straightforward. A modus. What is a modus? A modus is a contractual term that burdens the rights of one or more of the parties. It is an additional obligation in terms of the contract. Let's see. Mr. Sharuma must be so tired of me always using him as an example. Mr. Hayala, what sport are you involved in?
I played volleyball and soccer, ma'am.
You play, volleyball and soccer.
That's correct.
Okay, wonderful. Are you good?
They used to call me Ronaldo.
Ah, perfect. I'm so proud of you. Okay, so an example of a modus would be NUST offering to pay for your studies if you play soccer for the NUST soccer team, but you must also coach them. So there's NUST offers to pay for your studies. You could study free of charge. That's their obligation. Your prime obligation is to play for the NUST football team, but a modus, an additional obligation. You must also coach the team. Easy to understand. Do you understand that?
Yes, ma'am.
Yeah, it's straightforward. It's really straightforward. That type of additional obligation, you get this, we give you this, you must do that, but in addition, you must also do something else, is known as a modus. These are just fancy legal terms. We're lawyers, we like using big words. Okay, a warranty. I don't need to explain what a warranty is. The word warranty can also use the word guarantee if you like. They essentially mean the same. I'll accept both of them. You all know what a warranty is. A promise of the absence of certain bad qualities or the presence of certain good qualities. A cancellation clause, once again, means exactly what it is. It gives one of the parties the right to cancel a contract. And in many instances, lays out the procedure to be followed. You must give so many days notice, you must pay so much money, etc., etc. We've come across cancellation clauses before. Last week, when we did breach of contract, we saw remedies for in the case of breach of contract, you can either claim specific performance, which is the preferred remedy, or cancellation. Then we saw that the courts don't like cancelling contracts. They prefer to uphold them. Courts will only allow cancellation if specific performance is not possible, not feasible, or if the parties have in advance, at the time of contracting, agreed to give each other the right to cancel the contract by way of a cancellation clause. So it means exactly what it says. A penalty clause also very much what it says. In the event of non-compliance, one of the parties is required to pay penalties. Building contractor agrees with the city of Windhoek to renovate the Sam Nujoma Stadium. Renovations must be done, completed by a certain date. Contract contains a penalty clause. If not completed by that certain date, they must pay the city of Windhoek X amount of dollars per day that they are late. An entrenchment clause. You've learned that contracts don't have to be in writing, but they can be by choice. An entrenchment clause you will only ever find. So these other clauses like a guarantee, whatever, can also be in an oral contract. I agree with Mr. Ayala that he will buy my car, and I guarantee that it doesn't have engine problems. Doesn't have to be writing. The warranty, the guarantee is applicable, is enforceable. An entrenchment clause, on the other hand, you will only find if the contract is in writing. An entrenchment clause states that if the contract is in writing, then any subsequent amendments must also be in writing. So I enter into a contract with Miss Justina, a written contract that she can rent a room in my house for $1,000 a month. Now, an entrenchment clause isn't implied. The fact that it's a written contract doesn't mean it automatically has an entrenchment clause. But in our written contract, there's a clause that says any amendments must be in writing. So we've agreed for $1,000 a month. She comes to me and says, well, she's run into a bit of trouble. She can only pay $500. I say, okay, it's fine. But we don't write it down. We just agree orally. And then end of the month, she wants to pay $500. And I say, no, it's $1,000. And she says, but you said, doesn't apply, isn't relevant, isn't binding if there's an entrenchment clause. If we didn't put in writing, we've reduced the rate to $500, our oral agreement will not apply. Related to the concept of an entrenchment clause is the legal rule called the Parel Evidence Rule. Parel Evidence Rule also only applies in written contracts. It is a rule of evidence that if a written contract is the exclusive record of the transaction and no outside evidence may be brought to prove something different to the written record. So if Justina ends up taking me to court, or I end up taking her to court because she's not paying me $1,000, she's only paying $500, and then I submit the written contract that says $1,000 to court as evidence. She says, no, I can call Sharuma and Hayala as witnesses that she agreed to something else. Parel Evidence Rule, no outside evidence may be brought. It's not of major impact or importance. It relates to written contracts. Okay, goodness, that's literally it. So yes, just to summarize, there are many other types of clauses. These are just some that we've selected that you'll come across most commonly. And of course, there are other clauses that can be used in contract incidental terms that add detail that don't necessarily have a name. It's just information. They're all binding. But you need to know these select few. I can give you an example, ask you to identify it, or alternatively, ask you to give me an example. Any questions? Okay, your quiz on Friday evening covers up to what we have done now. So I will quickly save and download this recording and share that on the group again. I believe there were some students that had some connectivity problems. I'll forgive them for today because our internet does tend to go down the drain if the weather is as wet and rainy as it is at the moment. But I am disappointed in general with the class attendance. 3 students attending class. I'm going to stop teaching. Okay, thank you so much. Good luck for Friday.